1983. He is the past chair, sorry, thank you, Debbie. He is the past chair of both the probate and estate planning section and the estate and gift tax committee of Hawaii State Bar Association. Scott has written various books and articles for lawyers, other estate planning professionals, and the general public concerning estate planning. He has served as a lecturer for the Hawaii Institute for Continuing Legal Education, the National Business Institute, the National Estate Planning Conference, Mediation Center of the Pacific, and the Senior Counsel and Young Lawyers Division of the HSBA, as well as a wide variety of churches and community groups. I'll go on also to say that he was a past president of the Christian Legal Society of Hawaii, past president and chairman of the Board of Financial Planning Association of Hawaii, and the past president of the Board of Trustees of the Foundation of the Rotary Club of Honolulu. Yay! And prior to forming Estate Planning Council, Scott was a partner in the Honolulu firm of Goodsell, Anderson, Quinn, and Stifel, where he started his legal career in 1983. He left the Goodsell firm to join a smaller firm in 1994 and then established his own firm in 1999. He is a graduate of the William S. Richardson University of Hawaii School of Law, Duke University, and Kau High School. So everybody, please welcome Scott Makuakane. Scott, it's all yours.
Aloha, thank you so much. Well, what we're going to do is, I guess, take about the next, what do we got, about 40 minutes to talk about some basic estate planning concepts. Before we get there, though, let me just say that there are a few questions that we ought to ask before we even start down the road of estate planning. And the first question really is, why do we do it? And the why behind estate planning might be a little bit surprising. At least my philosophy of estate planning is that estate planning really isn't about your stuff. It's about people. It's about you. It's about people who would be affected if something happened to you. And orienting estate planning around people rather than things can help us kind of work through issues and make sure that we're hitting all of the human issues that are involved in estate planning. It's not all dollars and cents. It's not all finances. A lot of it is feelings and how people are going to be able to process someone's estate plan, how people are going to be able to benefit from it, how people are going to be blessed from it. So the why behind estate planning, at least in my philosophy, is people. Okay, so what can be done when it comes to estate planning? Well, one of the things we can do is realize that there's lots and lots of rules out there. There's rules about everything. There's rules about where you can go during COVID. There's rules about which side of the road we drive on. There's rules about taxes. There's rules about what makes a valid will or a trust. Well, when it comes to estate planning, the really cool rule is we get to write our own rules. So what our estate plans end up being are the rule books that cover things like, well, what if there comes a time when I can't manage my own stuff? Who's going to manage it for me? Do I want to leave that to chance, or do I want to have a plan? Do I want to have specific rules set out about who's going to step in and do things on my behalf and what's ultimately going to happen with my stuff? So what can be done when it comes to estate planning is we can recognize the fact that we get to write our own rules. And that's what our estate plans are. They're our rule books. So how do we do that? Well, estate planning really is a process. And it's one that doesn't really end until the estate plan has played out completely and all the assets are distributed and everything that the estate plan was designed to do has been accomplished. But the process begins with evaluating where we are now, looking down the road and thinking where we want our estate plan to get us and our loved ones, and then coming up with that rule book to get us from here to there. Now, estate planning, a lot of times people think of as being a matter of avoiding taxes and avoiding probate. And those are great things to do. We try to do those in every estate plan. But there are things that probably are more important if you really sit down and think about it. And so to me, probably the most important part of estate planning is maintaining control, helping our clients maintain control over their stuff. And control is a much better basis for an estate plan than simply avoiding taxes, avoiding probate. Because in some circumstances, you might sacrifice a little bit in terms of tax liability, or you might sacrifice in other ways, but you really don't want to give up control over your stuff. Next step is providing for me. Oh, and my spouse. Now, I didn't really forget about my spouse. The reason I have my spouse there in parentheses is kind of for the same reason that when you take a plane trip and you go through the safety briefing, one of the things they tell you about is the masks. And I've never been on a flight where the masks appeared other than during the safety briefing. I pray I never am. But I know what to do when the masks appear. I grab the mask and I put it on the person next to me, right? No, they tell you to put the mask on yourself. Why? Because you're selfish? No, because if you don't, you're going to be unconscious, very likely in a very short period of time, and you're going to be no help to anybody sitting around you. Well, estate planning is kind of like that, in that we got to take care of ourselves in order to take care of the people who, figuratively speaking, are sitting around us. The next step up, sorry, I'm going the wrong way. The next step up this planning pyramid is providing for other family members. And then the tip of the pyramid, notice it's not the base, it's the tip, is minimizing those taxes and expenses. So that's where probate avoidance comes into play. That's where tax planning comes into play. But we want to do the probate avoidance and the tax planning in the right order, in the right context, so that our estate plans really are going to benefit us and are going to benefit our loved ones. So let me propose this definition of estate planning based on what I've said so far. First of all, I want my stuff to be under my control while I can control it. I want to control my stuff while I'm alive and well. And I've never had a client that didn't want to be in control of their stuff. So that's a pretty basic need, a pretty basic desire. And that's one that we can effectuate through the estate planning process. Next step is I want to plan for me and my loved ones if I become disabled. Now, probably most of the people listening know that the if is a very small word, but it has very big implication when it comes to estate planning, because each one of us has about a 70% chance of needing some kind of long-term care before we die. And it may be because we're completely incapacitated. It may be because we're impaired in some way. But disability planning is absolutely critical, and it's become more critical over the years. When I started practicing back in 1983, we didn't completely ignore disability planning, but it wasn't as important because back then people did things differently. They lived and then they died. We don't do that anymore. Medical science, thank God, has come up with a lot of really neat ways to keep us going. They can keep our hearts going, they can keep our lungs going. They just haven't figured out yet how to keep our brains going to keep up with the rest of us. So the consequence is that we live longer, hooray, but the quality of life may not be what we would want. So planning for disability is something that's absolutely critical for anybody, irrespective of family situation or other circumstances. Planning for disability is one thing that we really need to focus on in the estate planning process. And then ultimately, I want to give what I have to whom I want, when I want, the way I want. And when I die, and unfortunately there's a 100% probability of that happening, but I want my stuff to go to the people I love without unnecessary cost or delay or loss of privacy. So how do we do that? Well, there are a variety of ways that we can pass things on. One of them is this thing called joint tenancy, or I call it on this slide, poor man's estate planning. Joint tenancy is cheap, it's easy, and anybody can do it. All you got to do is go to the bank, or you can do a deed to convey property to you and somebody else's joint tenants. And what that means is, if you pass, the other joint tenant or the other joint owners get your share. And then the last one standing of the joint tenants, the joint owners of this bank account or whatever it is, gets to take it all. But there's some issues with that. Let's say that mom and pop have 3 kids. And just for fun, let's name them Mo, Larry, and Curly. And let's say mom and pop put Mo, Larry, and Curly on title to their house. They put them on title to their bank accounts because they know that dad is going to die first. He's the oldest one. So the oldest one in every family always dies first, right? Well, not in my family and not in most families that I know of. So there's a built-in fallacy to joint tenancy in that you might think you know where your stuff is going if something happens to you, but in real life, you don't, because we don't know in what order people are going to pass. But let's just say that mom and pop are satisfied the joint tenancy is going to advance their estate planning needs. So they put Mo, Larry, and Curly on title to all their stuff. Everything goes fine. 10 years go by, no problems. 12 years go by, 15 years, no problems. But then there's that one fateful day. Mo comes running in the house. Mom, Dad, I got some bad news. Remember that car accident I was in about 3 years ago? Well, turns out it was my fault. And the other people in the car accident sued me. They got a judgment. And at the time of the accident, unfortunately, I didn't have the money to pay my car insurance premium. So I don't have any coverage. So these people who have gotten the judgment against me are looking around for assets to go after in order to satisfy their judgment. And I seem to recall, Mom and Dad, you put me on title to the house and you put me on title to your bank accounts. Do you think that's going to be a problem? Well, 20 minutes later, Larry comes running in the house. Mom, Dad, got a problem. My wife has left me. She wants a divorce. And she thinks she's entitled to half of everything I own. And her lawyer is asking me questions about everything I own. And I think I'm going to have to tell him that I'm entitled to the house and I'm entitled to your bank accounts. I'm a part owner in those. Do you think that's going to be a problem? Well, the answer is, yeah, that's a real problem because now we have at least 2 people out there who are very interested, very motivated, very able to possibly force a sale of the house, to get into the bank accounts. So what mom and pop did by putting the kids on title to their stuff is they gave up control. And remember, that was the foundational piece of estate planning that we talked about a couple minutes ago. So mom and pop broke the cardinal estate planning rule in that they gave up control over their stuff by using joint tenancy. Now, that's not to say that joint tenancy in every circumstance is bad. Estate planners use joint tenancy all the time, but the important thing is to use it with your eyes open and to understand the consequences of holding stuff in joint tenancy. So the downsides, again, are the creditors. That was Mo's problem, the car accident folks. There's predators out there too. And in this case, we're using that term for Larry's ex-spouse, who wants a piece of his stuff, even though it never really was his, but has the right to be able to dig into mom and dad's stuff in order to satisfy claims arising out of the divorce. And then remember, there were actually 3 kids. It was Mo, Larry, and Curly. Now, Curly falls into this very special category of beneficiaries that we use the technical term for these folks is the baboos beneficiaries. And if you don't know what baboos means, ask one of your local friends, and they'll probably tell you that it means stupid, which is basically what it means. And so the point here is that not all beneficiaries, just by virtue of the fact of outliving you, it doesn't mean that they have the ability to hold on to whatever they receive. So one of the things that joint tenancy can do is sacrifice the opportunity to put special rules in place for the baboos beneficiaries, if there are any in your estate plan, and for most of us there are. But it's the opportunity to protect against not just the creditors and predators, but the bad friends, the bad habits, and maybe just an inability to hold on to money. Sometimes it makes sense to have adult supervision over even our adult kids. So what joint tenancy does, again, is it exposes assets to creditors and predators, and it sacrifices the opportunity to put special rules in place for the folks who need special rules. Now, if you don't use joint tenancy to pass your stuff on, and let's say you don't have any estate planning measures in place, well, your stuff is going to have to go by way of either the operation of law. In Hawaii, we have something called an intestate succession statute. All states actually have that. And what the intestate succession statute is essentially a will that was written for you by our legislature. And what the legislature did is basically set out the rules to pass our stuff on if we've made no prearrangements through an estate plan. And the legislature tried to figure out, well, logically, where would somebody want their stuff to go? And frankly, the legislature did a pretty good job of that, but it doesn't work in every circumstance. And one of the problems with it is you never know where your stuff is going to go if you're going to rely on the state's will, intestate succession, because you don't know who's going to die in what order within your estate plan. So relying on the state's will really is a recipe for disaster. You might be lucky, you might get exactly the result you want, but the odds really aren't very high of that happening. So with respect to any individually owned assets, they pass by way of your will. So your will is either that document that you have a lawyer prepare, or maybe you do it yourself. In Hawaii, we can do what we call holographic wills. Or you use the state's will. You do nothing and you just go with the default rules. But that way of transferring your stuff is probably going to necessitate a court proceeding called probate. And whether you've experienced probate or not, you probably know that there are a lot of downsides to probate. Probate can take a long time. Probate can be very expensive. Probate can be complicated. Probate can be essentially a forum for people to get together and fight over your estate. Generally speaking, probate is a wonderful thing to avoid. Another thing about probate, and to me, probably the most distasteful thing about probate, is it's a public proceeding. Anybody who wants to go down to the courthouse and look through the files and see what's there, see what you own, see who your family members are, and those kinds of things, are exposed in a very general way, potentially through the probate process. So it's a tremendous sacrifice of privacy. So for that reason, all by itself, probate is a wonderful thing to avoid. And then when you compound it with the other kinds of things like the expense and the delay and the complication and all of that kind of stuff, probate is a wonderful thing to avoid. Anytime you can avoid going to court, that's probably a good day. Now, what the law has come up with to get around the problems of joint tenancy, to get around the problems of probate, are these things called trusts. Now, a trust is really kind of an odd thing in that it's a complete fiction. Trusts don't exist in nature. They don't grow on trees. They don't mine them out of the ground. It's a concept from the mind of man. And frankly, our law of trusts comes from the law of medieval England. That's where trusts got started. And another time, when we've got more time, I can give a little history lesson and talk about how trusts evolved. But understand that what a trust does is it divides the ownership of assets between the legal, the title holding component, and the beneficial or the enjoyment component. The elements of a trust are these. First is the trust maker. If you're setting up a trust, that's you. You're the trust maker. Makes an agreement with a trustee to manage some stuff for the benefit of one or more beneficiaries. Now, in Hawaii and all 50 states, same person can be trust maker and trustee and primary beneficiary of the trust. And usually when we set up revocable living trusts, that's exactly the scenario. The trust maker will also be the trustee and will also be the beneficiary during that person's lifetime. Now, in order for the trust to exist in the first place, something has to change hands from the trust maker to the trustee. That's the stuff. That's the trust assets. So if I want my house, for example, to be in my trust, what I've got to do is sign a deed from me as me to me as trustee of my trust. Similarly, if I want a bank account to be in my trust, I got to go down to the bank and I've got to ask them to change the title on my account from me to me, comma, trustee. And then my trust agreement, the rule book that I've devised with the help of my trusted advisors, is going to be what governs what happens to the stuff that's in the trust. Now, the fifth element of the trust is the rule book. In other words, there needs to be a written document that tells the trustee exactly how to manage the assets. So while the trust maker is the trustee, it's not that big of an issue. But when the trust maker can no longer be the trustee, the rule book has to set out what's supposed to happen then, who's supposed to step in and take authority, and what they're supposed to do with the assets. Now, there's lots and lots of different kinds of trusts out there. One of the very big categories is what we call testamentary trusts. Now, estate planners today don't use a lot of testamentary trusts because in order for the trust to exist in the first place, you got to go through probate. So a testamentary trust is wonderful for providing guidance for the administration of assets after you're gone, but it does nothing for you while you're alive. And again, it has to, your will or has to go through the probate process in order for that testamentary trust to exist. And I think, I was just trying to see, I thought maybe a question was coming through. So testamentary trusts are out there. There's lots of great examples, one of them being Bishop Estate, another being Campbell Estate, which of course has moved on. It's no longer in a trust. It's a limited liability company. But trusts have, testamentary trusts have a very long history, and they're great for what they do. But most of the time, a better approach when it comes to trust planning is through what we call a living trust. Now, living trusts also break down into a lot of different categories, but the big ones are revocable and irrevocable. And I just happen to have an example of each. This is what I like to use as sort of a picture of a revocable trust. If you didn't have a little red wagon when you were a kid, you know somebody who did, so you know how they work. Let me just grab some trust assets here. So what happens with the revocable trust is you take some stuff, and this may be the deed to your house, it may be an actual bank account, it may be cash, it may be whatever you own, but you put it into the revocable trust. And then the trust is the container that carries this asset through your life. And what it does is that it avoids the problems that come up if you don't have any planning in place. So one of the problems, if you're just walking through life holding your stuff in your hands rather than having it in your revocable trust, is if you become incapacitated or if you die, well, what happens to your stuff? It ends up in a mess on the ground. Who cleans it up? Well, if the reason for the mess on the ground is that you died, then the person who cleans it up is called your personal representative, which is the same thing as executor, but in Hawaii we call it personal representative. And that person has to gather your stuff up, pay the bills, and make sure that whatever's left goes where it's supposed to go, either according to your written will or according to the law of intestate succession. Now, if the reason for the mess on the ground is you became incapacitated, then the person who cleans up the mess, grabs the stuff, starts paying the bills, and taking care of you financially is called your conservator. Now, a conservatorship proceeding is another court proceeding, very worth avoiding, because conservatorship is actually probate on steroids. All the bad things I said about probate go doubly bad when it comes to conservatorship. Conservatorship, first of all, begins with somebody having to go down to the courthouse and prove to a judge's satisfaction that I've lost my marbles. And they do that on the public record. And then the court is going to oversee the administration of my stuff in the conservator's hands by way of requiring the conservator to come back into court from time to time to account for what they've done with my stuff. So conservatorship, again, very worthwhile avoiding. Now, if I've got my revocable living trust and I've got my stuff in the revocable living trust, if something bad happens to me, the only thing that hits the ground is the handle of my revocable living trust, but attached to the handle of my revocable living trust is my rule book. And my rule book says various things like, well, who picks up the handle and pulls this thing from now on? Those are the successor trustee instructions. It says what kind of things can go into my trust. Those are the investment instructions. It says when and what kinds of things come out of my trust and who gets them. Those are the distribution instructions, and they're all set out in my rule book. Now, in contrast to the revocable trust, we have the irrevocable trust. Irrevocable trust is a little different in that the irrevocable trust, you see, has a lid. The revocable doesn't. So anytime I want to get into my revocable trust, no problem, I can do that. Not true with the irrevocable. With the irrevocable trust, you take your stuff, you put it in, but then you put a lid on it. And what the lid means is I can't get back in here any old time I want. I can't just reach in and pull the assets out. The rule book limits my ability to get back into the trust. Now, there can be some great reasons to create irrevocable trust. You might think, well, why would anybody want to put things beyond their own control? Well, sometimes you want to give them away without giving up all of the control over those assets. And there can be a variety of other reasons for an irrevocable trust as well. One of the very common kinds of irrevocable trusts is what we call irrevocable life insurance trusts. So let's just kind of think through how an irrevocable life insurance trust works. Take a couple of steps back. Let's say that in my family, I'm the breadwinner. If I die or I become incapacitated, poof, no more bread comes home. The bakery shuts down because the breadwinner is no longer able to bring home the bread. Well, one way to minimize the risk of that happening is to go out and invest in a life insurance policy, which will pay money to whoever I designate as the beneficiaries if something happens to me. So let's say I go out and I buy a life insurance policy and I name my spouse as the beneficiary, and then I die. Well, the insurance company is going to pay the money to the beneficiary, in this case, my spouse. So far, so good. But let's say one day my spouse is driving down the H1 and she hears this bing come from her telephone. And of course, nobody within earshot of my voice right now would ever do this. But in this circumstance, my wife, unfortunately, takes her eyes off the road, looks down at her phone, and looks back just in time to see the school bus that's pulled out in front of her. 27 kids on the school bus. And you know what? Every single one of them has a cell phone. So what happens? The cell phones go to the ear, the hand goes to the neck, and they all call their moms. And they say, Mom, guess what just happened? And how many of the moms do not know a personal injury attorney or how to get in touch with one? So now, all of a sudden, the money that I thought was going to be there for my spouse and my loved ones is actually there for the 27 kids on the school bus and their lawyers. And don't forget, the school bus probably has a driver. It probably has an adult chaperone or two. The point being that there's going to be a lot of people benefiting from that policy that I never intended to benefit from it. Well, what if instead of going out and buying a policy, I created one of these? I created an irrevocable trust, and I put into the trust enough money to start paying the premiums on a policy that I just happened to have qualified for. And I have a little chit chat with the trustee, and I tell him, hey, look, there's some money in the trust. I've qualified for this life insurance policy. And if you use the money in the trust to pay that initial premium, you're probably going to find that I'm going to keep putting enough money into the trust to pay the premiums. What do you think? Trustee says, yeah, no problem. That sounds like a great idea. And then I go home to tell my wife about this great idea. And let's kind of think through how she might react to it. Well, here's the conversation. Honey, you know that life insurance policy we've been talking about? Well, I've got a better idea. In fact, I've already done it. I hope it's okay. But I created an irrevocable trust, and I put the money that we were going to use for that initial premium into the trust. So now the trust actually owns the policy. And if something happens to me, the money doesn't come to you. The money goes into the trust. And the trustee, in this case, actually has unlimited discretion about whether to make or not make distributions to the beneficiaries. So, honey, what do you think? Well, what do you think, my honey thought? Her first question was, well, wait a minute, who's the trustee? And I satisfied her that the trustee, and obviously this is a true life story, I satisfied her that the trustee is somebody that is trustworthy and probably honest and a likable enough individual. But then my wife says, but wait, I think I heard you say that the trustee has unlimited discretion whether to make distributions or not make distributions to me. Is that true? And I tell her, well, yeah, honey, that's true. And the reason is that we need to have this neutral third party as trustee, and the neutral third party has to have the ability to make or not make distributions to you because, and then we go through the school bus story and I explain how if the money actually had gone into the trust instead of gone into my spouse's bank account, then we can protect it from the 27 kids on the school bus and their lawyers, and we can protect it from a whole bunch of other bad things as well. So the point is that irrevocable trust can be used to advance a lot of different estate planning objectives, one of them being simply to protect assets in the hands of or for the benefit of the people that we want to benefit through our estate plans and not the people that we don't want to benefit. Most people, for example, don't want to benefit their children's ex-spouses. Most people don't want to benefit their children's creditors. Now, sometimes people say, well, yeah, but that's their problem. They can deal with that. I leave it to them. And, you know, I pass the asset on to the next generation, and that's that. It's their problem from then on. The thing is that trust planning provides a lot of opportunities to protect our loved ones against eventualities that we hope are never going to happen. Now, we don't set up irrevocable trusts in order to help people be irresponsible or get away with anything. The reason we do the irrevocable trust and the reason we build the creditor protection that we can build into an irrevocable trust is essentially to give our loved ones the ability to resolve valid claims in as favorable a way as possible. If my beneficiary is able to go to a creditor, for example, and say, you know, there's money in the trust and you want some and I want some. Frankly, I can't get any right now because if the trustee makes a distribution to me, you're going to be able to grab it. So tell you what, why don't we be reasonable here? Why don't we come up with a resolution of this situation? And then you can get some money, I can get some money, we can go our separate ways. Now, most of the time, a creditor faced with the choice of getting something or getting nothing is going to be fairly reasonable. So again, what we're trying to do through creditor protection and estate planning is just put our loved ones in the best position possible to be able to resolve those valid claims. Now, when we start talking about trust planning, there are issues that come up, and some of them can be kind of subtle, but here's some of the big ones. Incapacity protection. You know, it is absolutely possible, and I've seen this play out in real life, where someone is a fine trustee. They put their stuff into their trust, they manage it for the benefit of themselves and their family for a very long time, but then they lose the ability to continue to manage assets effectively. What happens then? Well, in one circumstance that I'm aware of, senior family member developed Parkinson's, and he lived long enough after that for the Parkinson's to actually develop into full-blown dementia. All along, the trust maker was in charge of the trust. And toward the end of his life, he made a couple of very bad decisions that converted a large estate into a small estate. And it was just a couple of bad decisions. But there was nobody in the family who could stand up to him and say, hey, granddad, you really shouldn't be the trustee anymore. Well, one of the things that we can build into our rule books when we're doing trust planning is we can provide a way for our family members to be able to step up and say, you know, for your own good, for the family's good, it would be better if we had a different trustee. And you can actually empower people to fire you as trustee of your very own trust in order to protect against something bad happening to you health-wise that's going to impair your ability to hold on to assets. So I offer that for your consideration. Here's a point that I will illustrate with a story. Fred and Wilma are sitting on their back lanai one evening. And Fred turns to Wilma and he says, Wilma, if I were to die, would you remarry? And Wilma says, what's going on? Well, are you okay? And Fred says, oh, yeah, I'm fine. It's just, this has been on my mind. I wanted to share with you that if something ever happens to me, why, it's fine with me if you remarry. And Wilma says, okay. A few minutes later, Fred turns to her again and he says, Wilma, if I died and you remarried, would you have your new husband come and live in our house? And Wilma says, Fred, I was just kind of starting to enjoy the evening. The sun has gone down. The birds are found all their nests in the trees. The breeze is just starting to pick up. Do we have to talk about this right now? And Fred says, well, I'm sorry, Wilma. It's been on my mind. It's important to me. I need you to understand that if I die and you remarry, it's okay with me if your new husband comes and lives in our house. Wilma says, okay. A couple minutes later, Fred turns to her again and he says, Wilma, if I were to die, at this point, Wilma's had enough. She stands up, she starts walking into the house. She says, Fred, you have now officially spoiled this evening. I'm going in. You just enjoy it out here by yourself. And Fred says, no, wait, Wilma, please wait. This is really important. I need you to understand that if something happens to me, if I die and you remarry, it's okay with me if your new husband uses my pickup truck. But I have one last question, promise, last question. If I die and you remarry, would you let your new husband use my golf clubs? Wilma says, absolutely not. Fred says, well, you seem kind of certain about that. Wilma says, he is left-handed. The implication, of course, being that Wilma has already done some estate planning that doesn't involve Fred. Most of the time when I sit down with clients and talk about, well, what if you died? Would you want your spouse's new spouse to be part of the distribution scheme for your assets? And most of the time people say, no, I don't. Actually, so they generally use more colorful language than that. But the point is, what we can do is build into the rule book provisions that would protect against the situation where dad dies, mom remarries, and new spouse inherits everything from mom and leaves it to new spouse's kids to the exclusion of the original spouse's kids. Nobody really wants to see that happen. And I've actually seen it happen a couple of times in my practice, and it's a sad day. So what we can do is we can build in rules that do things like say that spouse won't be a beneficiary anymore if they remarry. Or if that seems too draconian, we can say, well, they can be a beneficiary, but they can't be the trustee anymore. And maybe they can't have the power to appoint assets that you might give to a surviving spouse. The point being that we can circumscribe the rights of the surviving spouse so that we can protect the assets and pass them on to the people we want to pass them on to. The last person I want to see receiving any of my assets is my wife's next husband and his kids, to the exclusion of my kids. So remarriage protection can be really critical in the trust planning process. We've kind of talked about the creditor protection with that school bus story, but again, we can protect our beneficiaries' things from people who might come and try and take them away from them. Similarly, remember Larry in the joint tenancy scenario? Well, we can protect assets against divorce too. We can make provision in our estate plan so that when our stuff goes to our kids, it stays with our kids. It wouldn't go on to their ex-spouses if our kids got divorced. Another thing that we can address in the estate planning process is special needs. Sometimes there are scenarios where a beneficiary, let's say, is receiving governmental benefits, and if they inherit something from you, they may lose those benefits. So special needs planning involves making sure that we can enhance that special needs person's life with what we give them without disqualifying them from the assets that they're entitled to receive. So those are just some of the really critical points when it comes to trust planning. Now, we're kind of toward the end of our time, and I'd like to give a little bit of opportunity just in case there are questions. And I'm not sure how to access that. So if somebody can help me make sure that,
Yeah,
go ahead.
so I'll let you know if there's any questions. So folks, we're just going to use the chat box. If you do that, then I'll relay the questions, okay? So
Sounds
if you
good.
have questions, right? This is a good time to do that. And so far, nothing.
Okay.
Not as well.
Wait, hold on. So sorry, guys. Rick, I agree. I think Randall had a question, but he might have sent it not to the chat, to our.
Yeah, he
but-
sent it via Q&A. It says,
Oh,
in going back to your example on the poor man's estate planning section with Mo, Larry, and Curly, isn't the property automatically protected if it is a joint tenancy of primary residence, as well as if it is an investment property that's placed in a joint tenancy, thereby not forcing the sale of the investment property to satisfy the judgment that one of the parties is being litigated on? If the joint tenancy
Well,
hold up to provide protection on a primary residence as well as an investment property, would you advise that anyone create LLCs and not have their personal names on real estate property titling?
yeah.
At the bottom of the screen, see if you can see where it says Q&A, and maybe you can read the question yourself because it's kind of a long one.
Okay, well, no, I think I get the question. They're asking, well, doesn't joint tenancy protect against that scenario? And actually, there is one kind of joint tenancy. It's not really joint tenancy. It's called tenancy by the entirety that does protect against creditors' claims in some circumstances. What tenancy by the entirety involves, as opposed to joint tenancy. See, with joint tenancy, all of the joint tenants have to be people. They have to be individuals. In other words, you can't have a trust be a joint tenant. You can't have a corporation be a joint tenant. All of the joint tenants have to be people. And they don't have to be related to each other in any way. Now, with tenancy by the entirety, on the other hand, a husband and wife, or spouses, reciprocal beneficiaries under Hawaii law, as long as they're registered, civil union partners, all have the ability to put assets in their joint names, but as tenants by the entirety, as opposed to joint tenants. And what tenancy by the entirety results in is that if there is a claim against one spouse, that creditor isn't going to be able to touch. On the other hand, if they have a claim against both spouses, then they can potentially get at the property. So it's not atypical at all for husbands and wives in Hawaii to own their residences as tenants by the entirety because of that protective quality. Now, if you take that tenancy by the entirety property and put it into your revocable trusts, you can run the risk of losing the tenancy by the entirety protection. Hawaii law, fortunately, provides a way to do that. You can actually take your tenancy by the entirety property, put it into separate husband and wife trusts or spouse trusts, and the tenancy by the entirety protection is preserved as long as you've got the right language in the deed, as long as you've got the right language in your trust, you can preserve that tenancy by the entirety. So joint tenancy doesn't provide that protection. Tenancy by the entirety does. The downside, of course, is that once the asset goes to the surviving spouse, then potentially creditors can go after it at that point. But through trusts and other ways, we can protect against those kinds of eventualities. Now, the other thing that the person asked about was using LLCs for creditor protection. And on a lot of levels, LLCs can be very helpful. They can provide just the creditor protection by forming a wall that creditors would have a very difficult time getting through if they had a claim against one of the individual owners of that LLC. But also, one of the things that the person mentioned was, well, what about keeping your name off of the real estate? And that can be a pretty good idea. Just for privacy purposes, you can use an entity to to hold title to things so that your name isn't going to be on the public record. And that can be really important for some people. I have a client who is a former Secret Service agent, and this person spent a lot of their career prosecuting identity theft. And they were very concerned that if, you know, the people that they put in jail get out and they come looking for this former Secret Service person, they might be able to do bad things to them just by finding out their address. But they might be able to do bad things, not necessarily physically, but they might be able to, you know, figure out how to steal assets electronically, or, you know, those kinds of things. So using LLCs can be a really great creditor protection and also privacy protection measure, as well as trusts. So I hope whoever asked the question, that pretty well responds to it. Any other questions? I noticed we're right up against the time, so I don't want to outstay my welcome here.
I don't see anything on my end. Debbie, did you have anything else on yours?
No, there was one more question. It said, do you have to have a trust checking account?
Do you have to have a trust checking account? Well, maybe the question, the intent of the question was, well, do you even put your checking account into the trust? The answer there is, in most cases, yes. If you're going to create a revocable living trust for estate planning purposes, you probably want to put just about everything you own in there. There are some things that we don't put into trust. We don't put retirement accounts, for example, but we may designate the trust as long as we've got the right language in the trust to protect the assets. You may designate the trust as a beneficiary of your retirement plan, but you wouldn't actually put the retirement plan into the trust. But when it comes to bank accounts, checking, savings, investment, whatever it is, yeah, it's a real good idea to have it in your trust, because if you become incapacitated and you have an account that's in your sole name, there may have to be a conservatorship proceeding just to access the money to pay your bills. So that can be a real problem. So to create a trust checking account, you go to the bank, you give them your social security number, if it's a revocable trust, as the tax ID number for the trust. And the banks are in Hawaii anyway, are pretty up to speed on figuring out how to title the account to make sure that your trust agreement, the rules that you set out in your trust agreement, are going to be the ones that govern what happens to that account. And again, I don't want to overstay my welcome. So procedurally, what's next?
There's one more question, a follow-up question. If you have beneficiaries on all your bank accounts, that would trump the trust assignments, am I correct?
Yeah. So, well, that would be an alternative. So rather than put the account into the trust, you can designate beneficiaries. And designating beneficiaries is fine. That will avoid probate. It'll be relatively quick and easy. But the question is, what's going to happen at the other end? First of all, the beneficiary has to outlive you, and the beneficiary has to be able, well, it doesn't have to be able to hold on to the assets, but preferably the person is going to be able to hold on to assets. But if they happen to be one of those baboos beneficiaries like Curly, the beneficiary designation isn't going to protect them at all. They're going to get the money and they're going to blow it as quickly as they can, as quickly as I would have blown it if I'd gotten a bunch of assets when I was 18, and probably anybody else listening would likely do the same. So there are some people that probably you don't want to pass assets on to by way of that beneficiary designation.
Does anybody else have any other questions for Scott? You can just unmute yourself also if you'd like to. I'm hearing no further questions. All right, well then, if we have no other questions, I'd like to thank Scott for his time with us and sharing all of this great information and great knowledge. I certainly learned a lot. And so just want to say many thanks to you, Scott, and look forward to working with you again.
Thank you very much. And thank you so much for inviting me to come on and share.
Appreciate it. All right, everybody, until next month. See you again.
Hui ho.
Hui ho.